Welcome back to Law and Crime Live. We still have some live feed coming out from the courtroom. We do know that they're doing charges in the Tex McIver case, but we wanted to get Adam Sostrin who's on air with us right now. Adam, thanks so much for being with us this afternoon. How are you?
It's so good to be on with my friends at Law and Crime in New York as I do this broadcast from Southern California.
Well, it's a sunny day here in New York today, so we're not envious of you over there in California today. But to keep us back on track on the Tex McIver case, we are doing jury charges right now. Tell our viewers how important this is for the defense, especially since we now know that lesser included offenses are included for the jury instructions. So talk to us a little bit about that.
About jury instructions?
Yeah.
Well, jury instructions are crucial to any case. They can make or break a prosecutor's case. They can make or break a defense attorney's case, depending on how an instruction is drafted and depending on what the evidence was in the courtroom. You can end up losing a case. That's why you have these hearings with the court, with the judge, outside the presence of the jury, to try to draft some type of an instruction that the jury can, based on that can help your client be found not guilty, or, the prosecutor would want to have it their way. Well, based on that instruction, it'll help them get a guilty verdict.
Right. And so what is the importance, I guess, coming from a defense perspective? Why is it important to have, or do you want lesser included offenses included in your jury charges?
Well, I mean, you do want something to hang their hat on that isn't as bad as, like, let's say, a murder charge. So, of course, in cases like this, you would want lesser included. Typically, though, if the evidence sort of speaks to it, the judge will say, I'm going to add these instructions for the lesser included because, it seems that there would be enough evidence to show that these offenses may or may not have occurred. So often the judges just add it.
So we do know, we've heard from our producers that what's in is criminal negligence, misdemeanor involuntary manslaughter, reckless conduct, felony involuntary manslaughter. However, they're not going to be telling the members of the jury the difference between a misdemeanor and a felony. How does that work? I mean, because usually we do know that they probably don't want members of the jury to know, because a lot of the times they don't want members of the jury feeling that they have some type of weight on them because of, the amount of time that may be associated with whether it's a misdemeanor or a felony. So in your view, why is this the fact that they're not telling the members of the jury the difference between a misdemeanor and a felony? How is that important to you as a defense attorney?
Well, we always, as a defense attorney, you kind of always want the jurors to think about the consequences. How could the state do this? Does it make sense based on this evidence that this person should get this and this amount of time? But that's evidence that's not allowed in a courtroom. The only thing that matters is whether or not certain crimes can be proven or not what the punishment could be, because that's not supposed to be what weighs into the jurors' minds when they go back into the deliberation room. It's supposed to be, hey, have these people actually proven their case, each of these charges beyond a reasonable doubt, not whether, oh, well, he's going to get 20 years from this, I can't accept something like this. I'm just not going to vote that way. I know we did it. Of course, they don't want that to happen. They don't want it's called jury nullification. It's supposed to be about the evidence alone, and that's it.
Right. And so let's talk a little bit about the defense expert, Mr. Ross Martin Gardner, who testified earlier today. We do know that he kind of put a blow in the prosecution's case in regards to the way in which the gun was positioned. So it was a great day for the defense today. Do you think, setting aside Mr. Ross Gardner's testimony for one moment, do you think that because of the great day that they had, do you think that made kind of a difference in whether or not Tex McIver decided to not take the stand in this case, or do you think the decision was made a long time ago?
Of course, well, you never, typically never say never, but usually you don't want your guy or your girl to take the stand because they could say something that might not be helpful, and often the best way to do it is rely on the state of the evidence, because your client could only screw it up. And based on his testimony that the gun couldn't have been in like a vertical position, that it could have just been, merely just on his lap, and there could have been an accidental misfire. Well, that goes right to the defense's case. That's fantastic day for the defense. That's how these cases go. Often the jurors just listen to the evidence and they think that's all there's going to be. But wait a second, the defense goes after, and they get to make their case. Right.
So what we know is on Monday, we're going to start with the rebuttals, for the prosecution's rebuttal. And what we can expect to hear from, I believe it's a financial expert, Dean Driscoll, and Putnam County Sheriff Howard Sills, who's also a friend of McIver's. So they said 3, but these are the 2 that we know about. Do you think it's really important for the prosecution to bring back another financial expert to rebut some of what was seen during the defense's case here?
If they don't feel, if the prosecution doesn't feel that it's made its case, it has this amazing ability to bring on rebuttal witnesses after the defense rests. It's so annoying. I hate it. I hate the discussions with the district attorney afterwards about how they may call a witness. It's like they get that last shot. I can't stand it. But that's what they do.
Well, it is their burden to prove. So, I mean, of course they would have the last shot, right? No, I said it's the prosecution's burden. They have their burden to meet. So, of course, they would have the last shot, right?
So they get the last shot. But I hate it. I hate that. I get that it's their burden. I just can't stand it on a personal level.
Right. Well, do you think that they're beating a dead horse here by bringing in a financial expert again? Or are there some ties, like some loose ends that they need to tie up?
Well, of course, if it's sort of recycled testimony, the jurors could find that annoying. They have lives, they have busy schedules.
Well, Adam, I'm going to cut you off for a second because we need to get back into the courtroom. There may be some interesting dialogue going on in the courtroom with the charges for Tex McIver. We'll be back in a moment.
Okay.
Welcome back to Law and Crime Live. What you just saw, we finished with jury instructions for the day, or jury charges, if that's how you like to call them. In the Tex McIver case, we do know that some lesser included offenses will be included, which is great for, I guess, both the prosecution and the defense, depending on which way that you look at it. We still have Adam Sostrin with us. Thanks, Adam, so much for being with us this afternoon. Court will resume Monday morning at 9 a.m. with the prosecution's rebuttal. We do know that the prosecution plans to bring in 3 individuals, one being a sleep expert, another being a financial expert, and there's another individual that they will be bringing in as well. Now, Adam, before we went back into the courtroom, I was asking you if you thought that the prosecution was essentially beating a dead horse by bringing in the financial expert again.
If they think that they haven't hit everything, and if there's one more point that they can make that's going to be salient, it's going to resonate, that they're going to remember it, they'll have the person on for 1 second, maybe that's okay. The problem is it kind of makes the prosecutor seem like they weren't able to do their job. So that's never that helpful in front of the jurors. Speaking of the sleep expert, I think I could have used that sleep expert last night.
Couldn't we all? We all know the last person that I couldn't recall, but I do know that it's the Putnam County Sheriff's Officer Howard Sills, who will also be brought on as a rebuttal witness, who is a friend of McIver. What I do want to talk to you a little bit about is the fact that some of the charges were dismissed against Mr. McIver, and one of them regarding his PR guy, I believe his name is Bill Crane. Do you think, of course, that's a win for the prosecution. We do know that it was in regards to intimidating a witness, and so the judge in this case found that the prosecution did not meet their burden in that case. Do you want to talk to us a little bit about that? I mean, yeah, go ahead.
Those are the things that those are defense attorney fantasies.
Right.
For those things to happen. So these aren't the drugs you're looking for, right? And at the end of the trial that says, well, you know what, the prosecution hasn't met its burden. They can make that ruling, at the end of the prosecutor's case or at the end of the defense's case, or before it even goes to a jury, let's say. And if they fail to meet that rule, because the judge, he decides the law, and the jurors decide facts, he can say that there's not enough evidence legally for this to support this charge. It can't be in front of the jury anymore. So clearly very helpful. Every single time you beat one of those charges, it's one less thing to think about, to worry about for your client regarding when it comes to sentencing.
Right. And, we're going to see what happens, I guess, on Monday. Hopefully the testimony will not be dry. As you stated, I kind of do have to agree with you. It's just another opportunity when we're discussing the rebuttal for the prosecution. It's just another opportunity for them to meet their burden, and they really haven't done it thus far, at least in my opinion. What do you think? From what you've seen thus far in the trial, what's your prediction for the members of the jury?
What's my prediction? Well, I thought that the defense had a fantastic day today. Really, really good. The fact that where the gun could have been positioned, it supports the defendant's case. So could the jurors say, hey, well, let's split the baby, do the famous biblical Solomon split, and say let's get some of the lesser charges? Of course, that's a possibility. So it was a good day for the defense.
It was. I'll agree with you there, Adam. It was a great day for the defense, and then we'll see how everything goes on Monday. Maybe the prosecution will, hit us with another blow. We never know, but we can't expect for the prosecution to complete its rebuttal on Monday, and then hopefully we'll be moving on to closing arguments, which is what we all love. Thank you, Adam, so much for being with us this afternoon. We love having you here on the Law and Crime Network, and we look forward to having you on again.
Sounds good. All right. Have a good one.
All right. Same to you. And so we're going to continue on. We are done for the day. As you do know, David Copperfield, that case is on a lunch break, so we will not be continuing coverage until most likely on Monday. So we'll be able to catch you up on that on Monday. Again, Tex McIver resumes on Monday as well at 9 a.m., as the judge said, around 9 a.m., when the members of the jury will come back and the prosecution will begin their rebuttal. And so we hope that you enjoyed your week with us here on the Law and Crime Network, here on Law and Crime Live, and we hope that you'll be back with us on Monday. This is Stephanie L. Willis. Thanks so much for being with us tonight, and have a great night.